Yes, Dr. Blackford. Good morning.
Good morning, my lord. May it please my lords. I appear for the appellant. With me are Ms. Wendy Duncan and Mr. Mark Jones. For the respondents, Mr. Michael Hilton, Queen's Counsel, and Mr. Kevin Powell.
Very good to see you all.
Yes, my lords.
Now, you can take it in the usual way that we have studied the papers, read the judgments, and are familiar with the arguments. Insofar as the case involves statutory construction, I think you can also take it that we are quite familiar with most of the principles of statutory construction and probably don't need much reference to case law. I think some of us may be puzzled by the notion of a principle of literal and purposive statutory construction. On the basis it sounds a little contradictory, and if you can, I'm not inviting you to go into matters which we probably are familiar with, but if there's some authority which indicates the existence of such a principle, no doubt you'll refer it to us. But in the ordinary course, we approach statutory construction looking, of course, at the words, but also seeking to understand their sense and, in particular, the mischief or the background against which they were enacted. How far that is really helpful here, where we have one statute and then 5 years later a separate statute in a more specific area, is obviously a matter for submissions primarily on the words of the statute. We don't seem to have much material about the background, but it may be pretty evident from the words of the statute. One thing which I think we would all be interested in is the extent to which the telecommunications legislation actually requires, in the process of authorization of transfer of a license, consideration of matters which would fall within the scope normally of the fair competition legislation. Doesn't seem to be a point which has been particularly developed, although it's touched on, I think, in one sentence in the Court of Appeal judgment. But it may be that you could develop that point. Subject to that, we look forward to hearing your submissions, which can, I think, in the light of what I've said, probably be condensed.
Yes, my lord. What we propose to do, taking into account what your lordship just indicated, is looking at the particular holding which is reduced to subholdings, which is a basis for grounds of appeal. We take the view that we should approach it this way because there's systemic implications with regard to these issues not being addressed in a definitive way. And so what we propose to do is to look at each of the grounds, just focusing on some of the salient points. Of course, your lordship can stop me wherever, and on the assumption, for example, that this is already covered and your lordships are comfortable with the position that we have taken.
Well, there's a certain amount of overlap, isn't there?
I beg your pardon?
There's a certain amount of overlap between different
Yes.
grounds, so we shall probably speed up.
So on the first issue, as to whether Section 17 of the Fair Competition Act, whether that is limited to collusive agreements in the ordinary meaning of the term as a conspiracy or secret.
But what's meant by collusive agreement?
That has.
Does the word appear in any legislation, either European or Jamaican?
My lord, the word has several meanings. It has a meaning in the competition sense. It has a meaning in the ordinary meaning sense. And it has a meaning with respect to Article 101 in particular. And what we propose to do is to show the differences and the fact that Section 17 of the FCA is not limited to collusive in either sense.
Well, by collusive, what you mean is deliberately intended as a matter of construction of the agreement or the arrangement to distort or prevent or restrict competition. Yeah. So, bearing in mind that the wording, let's look at the wording.
There are two problems about it, aren't there? One is that the language of the statute requires one to look at the effect and not just at the object.
Yeah.
And the other is that when collusive in competition law normally means no more than concerted. It doesn't involve any particular intention to defeat competition, but only an intention to do acts which have that consequence.
Your point in summary, I think, is that if you look at section 17.1, you see the words, this section applies to agreements which contain provisions that have or are likely to have the effect of lessening competition. There is no mention of collusive there at all, and that essentially is your point.
That is essentially our point.
And it's strengthened, or at least reinforced, by the fact that the actual wording makes purpose an alternative. It says that have as their purpose the substantial lessening of competition, or have, or are likely to have, the effect of substantially lessening competition in a market.
Yes, my lord.
So, and I think you were going to refer us to some authority which says that these are two different concepts, and that in one case the onus of justification is on one party, and in the other the onus is the other way around. But perhaps you could show us the best or clearest statement to that effect.
We would start with our section 17 and section 2 of the Fair Competition Act.
Right.
Yes.
We've got that. Yes. So show us some either an authority or else a text authority, case law or textbook authority, which draws the distinction which you say exists.
The distinction that we speak of, in focusing on the first distinction, as in the ordinary meaning of the word and the meaning of the word in the competition sense. In True Hand, for example, the case of True Hand.
I think it's Troy Hand.
Or
Troy Hand.
I do violence all the time, my lord.
It's German.
Right, in Troy Hand, which we find in where?
That's MS 1061, my lord.
6. Tab 6.
Right. So
let's look at that. Which paragraph?
We are tab 6.
paragraph 23. It says Article 101 makes a distinction between concerted practices and, in particular, the term agreement and decision by an association of undertakings with the sole intention of catching various forms of coordination.
Sorry, where are you? I thought you said paragraph 23. Am I wrong about that?
16. Where's my...
This case is more concerned with what is meant by an agreement, isn't it, than the present point that we're on?
Caribbean, though. Give me mine. Where's mine? Is that mine? Huh? I'm gonna need mine. Okay, 6. Yes. Paragraph, that would be paragraph 29, my lord.
29.
But it begins at paragraph 28, I would say.
Begins where?
Paragraph 28 of that case. It should be noted that according to the court's case law, in order for there to be an agreement, there must be the expression of the concurrence of wills of at least two parties. The form in which that concurrence is expressed not being by itself decisive. 29, as regards the term concerted practice, it's apparent from the court's case law that 81 makes a distinction between that term and in particular the terms agreement and decision by an association of undertakings, with the sole intention of catching various forms of collusion between undertakings, which, from a subjective point of view, have the same nature and are distinguishable from each other only by their intensity and the forms in which they manifest themselves. Here again, my lord, there is no definition of the term collusion, even within the case law itself.
But again,
there's no reference to collusion in the competition sense, or what it is to be understood to be meant by collusion in the competition sense. And we also say that that is also not reflected in what textbooks writers have to say about the term.
I mean, you're referring, are you, to textbooks like Mr. Wishes?
Mr.
Wishes or Sufferings or any one of
Professor
those.
Wishes.
It's the only purpose for which collusion is being discussed in paragraph 29 is that because the Article 81 distinguishes between agreements and concerted practices, you have to find something that falls short of an agreement, but which is nevertheless forbidden. And all that they are doing is using collusion as a synonym for concertation.
Or, I'm sorry?
For concertation.
Concertation. Acting
together.
together.
Acting consciously in conjunction with someone else, even though not pursuant to an agreement. I mean,
That is, my lord, I agree with you. That is a meaning that the term can bear. What we're saying is that it is not limited to that when one looks at Section 17 of our Act.
Why are we concerned with this point? The point which you are arguing is that assuming there is some sort of concerted practice or agreement, and it could hardly be denied that there was at least an agreement in this case, it's not necessary to show that its purpose was anti-competitive. Parties may have thought it had quite a different purpose and was entirely anodyne if its effect was, and Lord Hodges put to you, and I put to you, the actual wording of Section 17, and I asked for authority on that. You referred to Professor Wish's book, which we have at tab 26, which seems to draw a clear distinction between agreements or concerted practices with a purpose and agreements or concerted practices which have an effect. And, I mean, is there any actual authority? This is a textbook. I'm sure that some of the cases there probably address this issue, which is the one we're on.
Concerted practices is not an expression which appears in Section 17, although agreement in Section 2 is defined as including an arrangement or understanding. But concertation is obviously the concept which underlies the notion of arrangement or understanding that is not an agreement, but the language is slightly different.
Yes, my lord. Our position is that it is sufficiently broad to accommodate agreements which are not necessarily collusive agreements, whether in the ordinary sense of the word or in the competition sense of the word.
Yeah.
Yes.
We don't seem to have, I mean, just looking at Professor Wish, if you go to tab 26, MS 1397, start at the foot of 1396. The word object in this context means not the subjective intention of the parties when entering into the agreement, but the objective meaning and purpose of the agreement considered in the economic context in which it is to be applied. And then you have some authorities which we don't seem to have. So it doesn't matter what their subjective intention was, if when you construe it in the economic context in which it exists, it actually has that meaning or effect, that's sufficient. And I think Constant and Grundig against the Commission is an extremely famous case, which we don't seem to have got, I think. But
one of the commonest forms of consultation is a situation in which parties have absolutely no contact with each other at all, but are aware of each other's practices and adjust their own in such a way as to reduce competition between them. It's a classic area in which Article 81, and I would have thought Section 17 in Jamaica, applies.
Yes, madam.
But do you have any authority to carry this point any further? I mean, you've got Professor Wish, but have you looked at, did you look at any of the authorities which he cites, which may discuss this point in detail?
Yes. There is.
I gather there isn't any Jamaican authority on it.
Right. There is a decision of the Commission against ANIC.
Right.
I don't want to do violence to the other word, so I'll just stop at ANIC.
Tab 10.
Tab 10
Yes.
at MS page 1111. And paragraph 112, paragraph 113. Secondly, it must be observed that if Article 85 of the treaty distinguishes between concerted practices, agreements
Which
between
paragraph are you reading from?
112.
112.
112, my lord.
It's MS 1130.
And decisions by associations of undertakings. The aim is to have the prohibitions of that article catch different forms of coordination.
Yeah, but again, this is on the same. This is on the same point.
On the same point, my lord. Yes.
That the Troyhand case was on, so it's not on the point which we're concerned with at the moment. At least not directly on it. Anyway,
But yes.
you produce Wish to us, and we've got the language of the.
Yes. We say on this point, my lord, just for emphasis, that collusion in the ordinary meaning of the word, which requires an intention, is a form of agreement which is caught by Section 17, but is not limited to that kind of agreement. It also catches non-collusive agreements. In other words, those agreements by virtue of which there is no intention to achieve the particular
When you say
result.
effect is enough.
Effect.
Yes.
Effect.
Yes. There's that point. Clearly, there's a purpose, there's effect.
Yes, yes, Madam.
Two separate things. And the other point, I think, as I understand your case, is that the section will catch an agreement which has an anti-competitive effect, even if the two entities, the two parties to the agreement, don't remain independent and in the market at the same time.
Yes.
You say there's nothing in the section to
limit
so
that.
restrict it.
Yes.
And you say it's for the respondents to demonstrate where they get that restriction.
Yes. I think that restriction comes from an understanding of collusion which requires, on an interpretation of Article 101, that the entities must remain separate and independent post the agreement.
Yes.
In other words,
That's a slightly different point.
which is a slightly different point, but
We'll come to it. But I mean, I
It
see
arises out of the collusion argument.
which is one of the definitions of collusion.
Yes. It's got to be continuing collusion, is the
Right.
defendant's
Well,
argument.
basically, the argument seems to be that merger control, even if not based on merger control in practice, is always based on an agreement or arrangement, almost by definition. But the suggestion is that merger control is no part of the FCA at all.
Right.
If that is so, then the same argument as applied to the EU treaty would mean that there was no power to control mergers under the EU treaty, because that's based on the same dichotomy between concerted agreements and practices on the one hand and abuse of a dominant position on the other.
Yes, that is a position which...
But that would be absurd, and it's completely contrary to the whole jurisprudence on the EU treaty.
Yes, my Lord, we respectfully adopt the Lordship's position on that.
If you want to, I mean, if one were to look for an authority, perhaps just looking again at Professor Wish on page 1398, European Night Services and Commission seems to be particularly clear as to what is involved in object and effect. The object and effect distinction, it discusses the effect and the onus of proof on the Competition Commission to establish a restrictive effect, even if it can't establish a subjective intention. Anyway, we can, unless you've got anything to add, we could leave that point.
Oh, forward.
Yep. So we've already touched on the merger or control point.
Right.
So what was the next point you were going to take?
The next point I wanted to look at in relation to that is the separate and independent undertakings point, unless, of course, your Lordship would...
Separate and independent undertakings.
Right.
Yes.
Because that is one of the understandings of collusion. And unless, of course, your Lordships are very clear on why that doesn't apply.
How does the argument work? The argument is that unless they can continue to collude after they've achieved the anti-competitive effect, which we assume for present purposes, the anti-competitive effect isn't relevant. But the statute applies to an agreement which has an anti-competitive effect. Yes. It doesn't say that there has to continue to be an agreement thereafter.
That is so, my Lord. That's one part of the argument. The other part of the argument is that...
I mean, if you had an agreement whereby, I'm sorry to interrupt, but if you had an agreement where one party simply agreed to shut up shop,
yes,
then on this argument, the Act wouldn't apply because there wasn't a continuing collusion.
Yes, my Lord. Yes. We laugh at that too, my Lord. Yes.
So if I pay you money to close your... Say I'm a shopkeeper and I pay you money to close your shop.
Right.
Yes.
That would have an anti-competitive effect, but wouldn't be caught.
Yes.
Yes.
It's right.
Right. Well, I think we've got the point, and you say it's as simple as that.
It's.
In a sense, a merger is the ultimate extreme of concertation.
Right.
Yes.
The sense in which, just to elaborate, if I will, the sense in which the separate and independent pre- and post-agreement argument is tied up with collusion is in this sense. The argument is that the section is really governing undertakings.
Yes.
And that when one looks at an agreement which results in two companies becoming one, that really what should happen is that Article 86 or our Section 19 to 21 should really govern that, as in abuse of dominance.
That's abuse of a dominant position.
So that's the position.
Yes.
The position is that once it is a merger, then it is now subject to the discipline of 19 to 21 or abuse of dominance because of what is called this invention of once it is a merger, we're dealing with the structure of the market as opposed to market behavior or behavior within the market. In other words, behavior within the market is seen as comprising two companies remaining in existence post the agreement. And we're dealing with structure once we touch on a merger, the structure of the market. And that is governed by 86 or 19 to 21, as the case may be, of our
governed by Section 86
So that's the,
or 19 to 21, yes?
that's the respondent's argument.
So rather than by Section 17 of the...
Section 17 of the FCA,
Yes.
but also sections 19 to 21 of the FCA, which
deal with
deals with dominance. So the position would be that once we have a merger, then 17 is no longer relevant. It is now 86 or 19 to 21, as the case may be, because we're now dealing with not market behavior, but market structure, as the case may be.
But that dominant position is...
That's market behaviour. Agreements and arrangements is market structure.
I mean, dominant position is where you can dominate your competitors, but Section 17 deals with lesser behaviour, namely substantial lessening of competition where there is competition. There's nothing which says that you're allowed to distort competition to the point, as long as you don't become dominant. The section is concerned with substantial lessening of competition, even if you aren't dominant. Isn't that the position?
I mean, is this case about Section 19 at all?
No, it is not.
It's about Section 17, isn't it?
It's about Section
Shouldn't we be
17.
focusing on Section 17?
Except that I make the point because
No, the
that
argument.
is a respondent's argument,
Yes. And you,
or at least I anticipate that to be.
Yes.
and you say there is nothing in Section 17 which so restricts the prohibition.
Absolutely nothing, my lord.
Right, well, then it's very helpful. Thank you. Let you develop your next point.
Yes, my lord. So we want to say, with respect to the characterization of 17 as concerned with market behavior, that market behavior really refers to any behavior by market participants, whether some remain in the market. In other words, the entering of an agreement itself is a kind of market behavior. And that is consistent with Section 17 of the Fair Competition Act. That is, to the extent that we're saying that it is limited to market behavior, an agreement is a kind of market behavior. Now, the section is not so limited because there's nothing in Section 17, or indeed Section 2 of the FCA, which says that it is limited to behavior in the market, as it were. But even if one were to read it that way, we're saying that one definition that could be accommodated certainly is that market behavior relates to the behavior of market participants, those who are in whether a vertical, horizontal relationship within the market. In this particular case, the two companies were in a horizontal relationship, certainly prior to the agreement.
It's a classic relationship, horizontal, where anti-competitive agreements or practices may take place.
Yes, my lord.
Right. Well, I think, I mean, just looking at your heads, we've probably covered the first two grounds, haven't we, that you were proposing to...
Yes, my lord. I think we and the second, I think, my lord, we can say that we have covered the second, which relates to the distinction between object and effect.
Shall we go to ground three?
And that distinction between per se rule and the rule of reason standard.
Yes.
So the third ground,
Rule of reason is
As-
rather fancy
The-
description. So, a requirement to prove the objective effect, but to leave that aside. Round three.
yes, our main concern in ground three is that the Court of Appeal proceeded on the view that result is determinative of intention
Well,
by relying on the presumption against business inconvenience as in this particular case controlling of its
but
interpretation
you
of
need
intention.
you need to identify the business inconvenience if you're going to deploy this sort of factor. So we're down back to the terms and interrelationship of the statute.
Yeah, yes.
How do they interrelate? You say the Fair Competition Act continues to apply, and I think you say because the Telecommunications Act is aimed at different things and introduces no more than a precondition for the assignment of a license. And that comes to the point that I put to you near the outset.
Yeah.
Can it be said that the Telecommunications Act covers the same ground as the Fair Competition Act? We see lots of references to the Fair Competition Act, which might be, some of which might suggest it doesn't cover the ground because there are certain circumstances in which you can go to the competition authority if the office wants to,
Yes, yes.
or if a third party raises a point. Tell us why the minister's authorization doesn't look at matters which are covered by the Fair Competition Act.
Well,
We want to look at the statutes, don't we?
yes, my lord. So at tab 4, my lord, which is the Telecommunications Act, and MS 994.
Yes, thank you.
And we could start first with section 17 of the TCA.
Right.
Section 17 deals with the authority of the minister to transfer a license.
Yes.
And
You need under 17.2, you need the approval of the minister for the transfer.
yes, my lord.
Yes.
And
under 17.3, the minister can only must grant the approval if satisfied of the requirements of 11.1a to b. Now, do they relate to the present problems?
The only relationship in 11.1a to b is the use of the term legal impediment, so that the minister may consider whether there is any legal impediment. And
it says that B is not whether the transaction is subject to some legal impediment, it's whether the applicant is disqualified from being a license by reason of a legal impediment. In other words...
and the applicant could be a company. Yes.
Is there some requirement that companies have to be fit and proper persons?
Yes, my lord.
Where is that?
Well, the office in 11.2a, in giving advice to the minister, has to determine whether the applicant of a license is a fit and proper person.
Oh, yes.
But these are the provisions governing the grant of licenses.
Yes.
All that Section 17 does is to empower the minister to withhold his consent if the effect of the assignment is going to be that the license would not have been appropriate to grant the license in the first place in those conditions. So essentially, it is simply updating the oversight of the suitability of the licensee,
But only in respect to A and B.
by reference to only with respect to A and B, by reference to the proposed merger.
Yes. There's nothing which says that the minister has to be satisfied that the agreement satisfies any particular requirements. It's, as my lord points out, it's got to be satisfied the assignee satisfies the requirements.
Yes, my lord.
Is there anything else which says that the Minister would look at the actual agreement, apart from...
No, my Lord. There is nothing in Section 17 that authorizes the Minister to look at an agreement.
Yeah, but the Minister in press releases has said that he has considered competitive considerations. But the test, I would suggest, is does the Act require him to do so? And your answer is no, it doesn't.
No. So what the Minister would, my Lord, what the Minister would in effect do is take them into account, but he couldn't address them. Because the Minister cannot substitute his mandate for that of the FTC.
Yes, because 17.3 says he shall consent to the assignment of the licence unless 11A and B
are met.
Are not met, yes.
And he doesn't have a competition mandate.
Yes.
And simply concerned to ensure that the assignee is the sort of person who would have been entitled to a licence under 11.1A and B in the first place.
Yes, my Lord.
I.e., he's got to provide the interconnectivity, to offer a universal service, to observe the conditions of the licence, and not to be an unlawful person under B,
yes,
not a disqualified person.
And on that point, my Lord, about interconnectivity, that is the only section or provision in the TCA that excludes the FCA with regard to universal service obligations.
Can we just look at that provision?
Nowhere else.
73.1?
73.1,
yes.
Then it goes on to 73.2.
Yes.
It says,
Except
as provided in 1.
Yeah.
Nothing shall be construed as affecting the right to refer a matter to the Fair Trading Commission in accordance with the Fair Competition Act, so that the independent jurisdiction of the FTC is recognized, maintained, supported, buttressed under this provision, except with a universal service. And the reason for that is that it's very clear. With regard to universal service obligation, there are no competition issues. That's why. That is why.
Can I just confirm, have you abandoned your argument, which you raised below, that in fact the present case fell within Section 73, subsection 2?
That it falls within...
I think you argued below that the FTC, the Fair Trading Commission, did in fact act on the information of LIME, L-I-M-E.
The position is...
The courts below have held contrary to you on that, as a matter of fact. So you're not... have you abandoned that point before us?
It was not the point that we were making before your Lordship.
I thought not.
The point that we were making before your Lordship, and if I were to address the point with the point you have raised about the point below, the investigation was initiated, and then there was a referral. So we can't say the investigation began as a result of the referral, which was never our point. We were simply relying on 73.2 to say that the matter was also referred, and that the investigation would have been justified under 73.2 in any event, even though we rested on our independent jurisdiction to initiate the investigation. So that was the point.
It would be an astonishing thing if 73.2 were read restrictively to say, well, the FTC can't get involved unless someone refers the problem to them.
Right, right.
That's an absurd...
yes, and in fact, both courts, the Supreme Court and the Court of Appeal, so held that there is independent jurisdiction of the FTC, certainly with regard to, by the Supreme Court, the operation of Section 5 of the Telecommunications Act, re-referral by the OUR to the
It would
FTC.
mean that the jurisdiction of the Fair Trading Commission depended upon an investigation into probably causation as to why it had acted. If it had acted because it had received a third-party notification, then the Act would apply. If it had acted independently a day before receiving a third-party notification, then the Fair Trading Act wouldn't apply. Anyway, we've got your point on it, and both courts have held. So let's move to the next point.
But the next point on the third issue, I suppose, my Lord.
Well, if
That's
there is
all?
a next point on the third issue, what is the next point on it?
Well, there can only be unjustifiable inconvenience if the business has been required to do the same thing twice. And really the arguments in relation to implied repeal are the same arguments. Your argument, as I understand it, is quite simply there is no merger control regime in the Telecommunications Act which could exclude or duplicate that which belongs to the FTC.
Yeah, yes, my Lord.
Yeah.
And
I mean, the only possible argument to the other way might arise if the Office of Utilities Regulation Act conferred on the Office of Utilities Regulation a competition regulation function, which would bring it within Section 73(1).
yes.
But it doesn't seem to. It seems to be concerned with the regulation of standards of service.
I mean, there is a provision in Section 35 for competitive
Safeguards, yes, my Lord.
And am I right in saying that Jamaica, OUR did publish draft safeguard rules a few years ago?
I vaguely recall such an occurrence.
But they did not extend, as I understand it, to merger control. They related to interconnection and things like such things as that.
I recall that to be the case, my Lord, but I don't have the exact facts.
No. I mean, if there were such safeguards, I'd be interested to see them.
To see them. So,
Does the Office of Utilities Regulation have an enforcement function in relation to competition, or is it only a rule-making function?
the OUR Act functions. At Section 4, my Lord, dealing with the functions of the office,
Yes.
says the office will have power to determine, according to the provisions of the Act, rates or fares which may be charged in respect of the provisions of a prescribed utility service. But there's nothing in the functions indicating that it is charged with competition concerns.
Well, 41F requires it to promote competition among carriers and service providers. And Section 35 gives it the power, after consulting the FTC and otherwise, to...
41F?
41F.
Oh, that's a telecom.
Sorry, I don't...
We were looking at the Office of Utilities Regulation.
Oh, I'm so sorry.
I'm sorry. Just coming on from Lord Sumption's
Yes,
question.
my apologies.
Right. Yes. Right. So, under the Telecoms Act, there is that. There's that provision for addressing competition matters, but it is not a provision which sets out that the OUR or is charged exclusively with that. Throughout the TCA, the Telecommunications Act, there are references to the Fair Trading Commission the application of the Fair Competition Act with regard to addressing competition concerns in the telecommunications industry. In fact, both courts, the Supreme Court and the Court of Appeal, held that the Fair Competition Act applies to the telecommunications industry.
Yes.
So there's no dispute about that, about the FTC's jurisdiction in dealing with the telecommunications industry.
Yeah.
And that it's not, despite the wording here, the FTC's jurisdiction is maintained.
Yes.
Yes.
I'm not suggesting
Yes,
otherwise.
yes.
But 4.1f,
Yes, my lord.
whatever is said in the Office of Utilities Regulation statute, 4.1f gives them this responsibility, and Section 35 seems to be the particularization of that responsibility in empowering them to issue competitive safeguard rules.
Yes, ma'am.
But no one is founding on any such rules as giving them jurisdiction in this case.
Yes, my lord. That's not my understanding.
If it had done this and had finalised after consultation with the Fair Trading Commission rules, and if then Digicel and Oceanic Digital had put to the office the agreement they proposed, and if the office had then consulted with the Fair Trading Commission and after consultation approved the agreement, then Section 73(1) would apply.
With respect to,
It would be outside the scope of the fair trading, outside the scope of the competition legislation. It would be resolved because the matter would have been dealt with under the guidelines developed in conjunction with the Fair Trading Commission, and it would have been led to an agreement approved by the office after consultation with the Fair Trading Commission. That would have been the way to do it.
Yes, ma'am.
But the argument now is that it can be done by simple ministerial approval, which doesn't look at these things.
Yes, my lord.
Yes.
Which is out of step.
Yes.
Right, shall we move on? I think you needn't, for my part at least, worry too much about Attorney General and Lockwood, interesting case about the beer trade 200 years ago. Whether it's right or wrong now is probably not going to concern us.
Very well, my lord.
Not binding on us.
If I may go to the alleged business inconvenience, if your lordships are require any clarification on that, if not, I could move on. But the argument of the respondent is that the interrelationship between the two pieces of legislation, in particular TCA 17 and FCA 17, gives the impression of they're blowing hot and cold.
If they deal with different things, then there's no inconvenience. So I think that's probably all you need, for my part, to say on that. But
Very well, my lord. So I need not detain you further on that. And unless, of course, there's any need for any clarification further on ground 3, I would go on to ground.
well, you're going to have to the chance to reply.
Very well,
to
and
Hilton's submission, so that
right.
you could probably leave it.
Right, yes. And in ground 4, we simply say that unless the FCA is expressly exempted, it applies to the TCA, unless one can say that the provision that one is looking at, it can reasonably bear the interpretation that the FCA was meant to be excluded by implication, if not expressly. And we have set out the legislative scheme of the TCA in that regard. And if your lordships were to look at paragraph 103 of our statement of case, which is at MS.
Yes, that's a helpful paragraph, setting out your case.
We wish to make one, if we could make one correction. At paragraph 105, we included section 35.
Yes.
We meant to include section 73(1) of the TCA because we have already included section 35 in the first category. As a second.
Oh, yes.
line.
So this should be not be section 35, it should be section...
Section 73(1) of the TCA.
Well, will it?
As the second category,
No.
I'm sorry?
It's the other way round. Oh, I see, in the second category.
In the second category.
Yes, it should be section 73, not section... Well, wait a minute, which is the second category?
It's stipulating situations where jurisdiction is expressly excluded.
Yes. Yes, I see. Yes, I see. Yeah. Yeah.
No. Okay. Right. So we're saying, my lord, that in these other categories, what we consider to be the third category, which has part 3, 4, 6, 7, 8, and so on, throughout. These are areas of the TCA whereby there is no express reference to the FCA. In this third category. But our position is that unless expressly excluded, the TCA, the FCA applies by virtue of 73(1), what is stated in 73(1), and also 73(2), on a parity of reasoning with regard to 73(2).
You have to find, I think your case is that it's expressed, it will continue to apply unless expressly excluded because
It is a prior statute which, as originally passed, you submit was clearly wide enough to cover this sort of situation. You therefore ask whether the later statute, which isn't an amendment to the earlier statute, it's a separate scheme,
Yes, ma'am.
impliedly or expressly, or clearly is perhaps the word, qualifies or abrogates part of the earlier statute. Isn't that the right approach?
Well,
Looking at the chronology,
yes, my lord.
you're dealing with a lesser statute, and in some way it's argued that the lesser statute prevails because it's inconsistent with the earlier statute, or must take over this territory from the earlier statute.
Yes. But in this particular case, the implied repeal argument would not go very far because of the references
Because there are lots of references.
Lots of references in the TCA with regard to the FCA. I mean, I would suggest, as I understand it, that one would resort to the implied repeal argument where both pieces of legislation do not make reference to either. So you use the later in time if, as one test, or the special takes precedence to the general, another test. Or another test is, this is dealing with a specific industry, and this is a general, another test. But, you know, in this particular case, there are references to indicate that those rules are to be not relied on in interpreting the interrelationship between the two. You know, this is our case.
Could it be said against you that, bearing in mind the number of references to the Fair Competition Act, there is none which expressly, you might expect it expressly to preserve the general authority of the Fair Competition Authority.
To preserve it.
In other words, you're looking for some indication that the powers of the competition authorities cease, but bearing in mind that in some respects it's been careful to say that they continue, but not in this respect, might that not be a factor counting against you? Why didn't they expressly preserve the powers of the competition authority in a general sense?
Well, they did, my lord. 73.2.
Yes, I see you say
73.1 and 73.2. They did.
The argument of,
Yes.
from absurdity.
Yes.
You say, well, if a third party can
Right.
involve the competition authority, it'd be ridiculous
Yes.
if it couldn't involve itself.
Yes. In other words, the position that we would take is similar to the position that was taken in Lockwood, that to disregard those provisions would be an absurdity because it would mean reading words out of the Act when it was a clear intention of Parliament that the jurisdiction of the FTC should be preserved.
Yes. Right.
Unless your lordships would like me to assist further on any other point.
I wonder if I could clarify one question of fact.
Yes, ma'am.
Do we know if the Fair Trading Commission responded to any approach by the Minister when the Minister was considering the application for assignment?
There were meetings between the Fair Trading Commission and the Minister's office. The Minister, from advice received from the Solicitor General's office, was advised that competition law concerns could not be addressed in the context of 17. As a matter of fact, that if they were to be taken into account and addressed.
Sorry, he was advised that competition law concerns could not be addressed.
Could not be addressed in the context of 17. If they were to be taken into account as a basis for not granting the license.
Right. Do we have that advice?
No, I don't with me, but it was, I recall, my lord, because I was privy to the meeting. But I'm sorry.
You were privy to the meeting. That sounds. I think.
Okay, I'm sorry. There is a. I'm sorry, my lord. There's a reference in the record.
Yes, I think it's a bit difficult for you to be giving.
I'm sorry, my lord. There's a reference in the record.
Well, I'm glad about that.
Yes. Okay. The reference is that's PC 205. That's what we call it.
205.
Which volume of the record?
Volume 1. Volume 1.
Volume 1, page 205, right?
And this is 206, I believe.
Statement by the Prime Minister. Here we are.
The Attorney General's department advised that.
Can we just read?
Sure.
Let's look at this, see what it is. Statement to the House. Right. He recites Minister shall grant. Yes. When is this made? This is after the event.
After yes, ma'am. I was starting.
Right, so it's page 206, you say.
Yes, at 206, in reference to, moving on from 11(1)(a)(b), the statement, well, what it states, and then it goes on to say the Attorney General's Department advised that under the law, does your Lordship see that?
Yes, the Minister has no expressed authority.
Has no express authority to impose conditions in the transfer of the license. The transfer carries with it all the obligations contained in the license unless by mutual agreement the terms are modified. Right? So, and then,
I'd say there were
and
voluntary.
then later on TC 209, the Fair Trading Commission is considering.
Oh, well, wait a minute.
I'm
Look
sorry,
at
some of them-
207 at the foot. Given these circumstances and the statutory constraints placed on the Minister in the exercise of his discretion, I have approved the acquisition of Clario by Digicel. So he's saying I had a limited power. It's underlined, the word shall is underlined on page 205, and they tried to have some voluntary agreements, and then you were referring over the page to something.
Yes, my Lord. The last sentence on page 209, PC 209.
Yes.
The Fair Trading Commission is considering specific steps that may be taken within its statutory functions to ensure that the acquisition of Claro by Digicel does not adversely impact on the consuming public.
What other factors happened? I mean, has the agreement been implemented, or is it all held up pending these proceedings?
No, the agreement has been executed.
So effectively, Claro has become Digicel's.
Yes.
Well, they can be divested.
Can they be divested? Yes, I was going.
No, my Lord.
Well, I presume, doesn't the Competition Authority, the Fair Trading Commission, have power to order any remedy it likes, or what's the statutory power?
Well,
can't it rectify?
No. Well, it could rectify in that way, because, and we have the, if I may.
What about my fourth point?
If I may indicate to the court some authorities that we have on the point.
Yes. Could not the Fair Trading Commission have obtained an injunction to stop the merger? It could have done, could it? Show us its powers.
Yes. It has, under Section 47, there is, perhaps, under Section 47,
Tab 3.
there is provision for injunctive relief. I mean, one way to read that provision is to say that it concerns prohibitory injunctions. One could also read it broadly to say it covers mandatory injunctions, but our reading of it is that it covers prohibitory injunctions. In this event, it would apply to an executory agreement.
Oh, I see, yes.
Executed agreement. But if it were to apply to, say, mandatory...
What are we looking at now?
I'm sorry.
Well, it ought to...
Section 47.
47.
That's 1B. Grant an injunction restraining the offending person from engaging in conduct described in paragraph A. So theoretically, it could, but our argument is that it would more reasonably apply in a situation whereby the agreement is executed.
Wait a minute.
I wonder about that. I mean, the powers of the court under Section 47 relate to a failure to attend or give evidence under Section 45.
Well, they also relate to refusal or failure to comply with a requirement.
Or failure to require with a
Yes,
requirement of the Commission.
Why can the Commission, if
There's a correction to this. Tab 13.
Yes.
1242 to 1315. That's the Jamaica Stock Exchange case.
What page?
1242 to 1315.
1315, yes.
At page 28 or 29 of the judgment.
Yes.
At page?
At page 28 or 29. Is 28 or 29? At page 29.
Page 29 of
That's 1270 of the bump.
Right.
yes. Okay.
Yes, my lord. And it's at the the third sentence On page 29, Section 47 must be read, however, replacing a reference to Section 45 with a reference to Section 46, the former being an obvious error in the legislation. And that's the Court of Appeal.
Ah, yes.
Ah, yes.
Thank you.
Yes,
That explains.
Yes.
Yes.
But what this permits is for the court to enforce a direction of the Commission. Now, if the Commission determines that a merger has occurred which is unlawful, the Commission can presumably direct that the two entities be separated.
My Lord Sumption, on a reading of Section 17, it's, and of course in conjunction with Section 47, it's a theoretical possibility. We say it's a theoretical possibility that could happen, but we say it's remote because of the distinction between an executed and an executory agreement. If I were to provide an example.
Merger control regimes very commonly provide for intervention in both executed and executory agreements. You either restrain the thing by injunction in advance, yes, or you unscramble it later.
Yes, that depends on how we read the injunctive relief in 47, whether it's prohibitory or mandatory. And I know that your Lordship's board has said that the distinction between the two is barren.
It's got to be either, hasn't it? Because B provides, maybe academic in this case because these things haven't happened, but B provides that the court can grant an injunction restraining the person from failing to comply with the direction of the Commission, if you read 45 and 46A together. Yes. So if you grant an injunction restraining somebody from failing to comply with the direction of the Commission, and the Commission has directed a divestment, then the court simply enforces the divestment order.
Yes.
I think there may be a problem, which you're recognising, that in relation to monopolies, under Section 21, there is an express power to direct the enterprise to take such steps as necessary and reasonable to overcome the effects of abuse in the market. Yes. But in relation to simple lessening of competition,
there's an enforceability.
There's an enforceability problem, and if the agreement's been...
If it's executed...
If it's executed... In other words, if I were to provide an example, if one has a cartel agreement for a specific duration of time, say for 1 year, and the competition authority finds out about it 2 years later, it's already executed, and it will be difficult to unenforce that agreement if it is for a specific duration. It started, it stopped, it was found out 2 years later, it's executed. So, as in this particular case, the only remedy would be in damages, because neither a prohibitory injunction would apply or a mandatory.
The remedy is the penalty.
The penalty, yes, my lord.
Well, you say the only remedy would be damages. I mean, it may not be necessary to go into the question whether you can have a divestment direction, but suppose you have a merged entity and the competition authority gives directions as to how the merged entity is to operate in a way that's designed to alleviate the anti-competitive effects. Are you saying the Commission couldn't do that?
Yes, certainly, my Lord Sumption. In fact, that is consistent.
And if it did, that would be enforceable by injunction as well. It wouldn't just be a question of damages.
Yes, my Lord. Yes, my Lord. That's consistent with our view. Yes,
anyway, we're not, at the moment, we're not directly concerned with that because, I mean, firstly, there was no attempt to injunct the parties from not enforcing the agreement. It has been executed, and you're interested in the question of principle, whether this is a matter on which the competition authority, the Trading Commission, can
act, and at least it could act by imposing a fine.
Yes.
Whether it could act by doing anything by way of directing divestment is not before us, and is a matter for future argument if it ever became relevant.
It hasn't yet proceeded to remedies, as I understand it.
Yes, yes.
But it hasn't proceeded to a finding.
That's
This is
exactly so, my lord. Exactly so.
The question is one of jurisdiction.
Honour's jurisdiction, my lord, yes.
It's come in front of the court, what, by way of friendly proceedings for a declaration, effectively, or unfriendly proceedings for a declaration?
Unfriendly.
Right. Proceedings can be both unfriendly and friendly, I hope.
More commonly in the...
Yes. Right. Well, subject to any other questions from my colleagues, I've got none. So thank you very much.
I thank you, my lord.
Indeed. Is there anything you wish to add, Ms. Duncan?
My friend has covered everything.
Thank you very much indeed. Yes, Mr. Hilton.
May it please you, my lord. My lord, in relation to that last question, if I may just remind the court that what happened is that the proceedings sought substantive relief and penalties, but an order was made that the question of jurisdiction would be tried as a preliminary issue.
Yeah. Yes, I remember that, yes.
My lord, if I may start with this issue of collusion, just to clarify our position. We accept, my lord, that the word collusion by itself merely means concerted behavior. I'm not at all suggesting, this is not our case, that it requires some conspiratorial element. The point that we sought to make in the courts below and seek to make before your lordship is that Section 17 of the Fair Competition Act is aimed at agreements to modify ongoing conduct in the market, ongoing market behavior.
Where do you get that from in Section 17?
I will take your lordship too. And I say, my lord, that the scheme of the Act leads to that conclusion, as do the authorities on Article 101, the EU cases. And we say, my lord, that that is what the statute and the section are aimed at, and not at something like a merger and acquisition. My lord, and on this first point, and this is before we get to the effect of the ministerial approval, this first point, therefore, the central issue is what type of transaction is the Act intended to address, and is this such a transaction? And I'd observe, my lord, that it is also not our case that once a transfer has been approved by the minister, I'm sorry, the agreement is not subject. There's nothing in the agreement that can be subject to the FTC's concern. And I think my lord asked whether the minister, there's anything to indicate that the minister inspected the agreement itself. And the answer is no. The minister approved the transfer. But it is important to note, my lord, that the agreement in this case did nothing more than address the transfer of the license and the business, and of course the shares. There is nothing in the agreement that has any restrictive covenants, for example, and in their pleadings, the appellant identified a number of clauses in the agreement that it said reached the section. And those clauses were all directly related to the share sale and transfer.
Are you saying that the mere acquisition of control by one competing entity over another does not lessen competition for the purposes of Section 17?
Yes, my lord, I am.
That's your submission?
Yes, because that is not the type of transaction that Section 17 is intended to address.
But surely,
Where do you get this from?
isn't it hugely anti-competitive on its face? What do you say about the example we gave of an agreement that someone should simply shut down their shop, their business, with the inevitable consequence that all the custom goes to the continuing operator? Is that not anti-competitive?
Yes, my lord. But my lord, when I said no to the question, I'm not saying it's not anti-competitive. It's anti-competitive in the sense that there's one less competitor.
Yes.
But may I?
But why isn't, if you either drive out of business or else persuade by agreement someone to go out of business, isn't that the classic sort of example of anti-competitive conduct?
My lord, I think there's a significant difference between an agreement. My lord, Hodge, I think, gave an example of paying your competitor to cease business or to cease carrying on
Yes.
a particular activity in a particular market.
Right.
I think there's a difference between, my lord, between that and an acquisition of an entity.
Well, I wonder about that, because if you have control over the competing entity, you are destroying competition. If you pay a competing entity to pull out of your jurisdiction, that's clearly anti-competitive. Where in the wording of Section 17(1) do you see a necessary implication that the agreements have to be agreements which require two parties remaining in the market to modify their behaviour?
There are no words in Section 17, my lord, that have that effect. And that is why, in answer to my lord's assumption, I said one needs to look at the structure of the legislation. So I accept that Section 17...
Is there any other form of merger control except for the Fair Competition Act?
No, my lord.
In Jamaican legislation?
No, my lord. And indeed, that may be why, in the minister's statement, it was noted that there's need for legislation.
Well,
And so there's an issue as to whether, and your lordships may have noted...
if your present submission is right, then there is no provision for merger control in the EU treaty either, because the whole basis of the EU's merger control scheme is Article 81, now 101 of the EU treaty, which deals with anti-competitive agreements.
Is that right, my lord? That, of course, is not my area, but it is my understanding that there's a separate article dealing specifically with merger control.
Not of the treaty. There are regulations, but they're based on the EU agreement control provisions.
Well,
Anyway, I mean, it does lead to some odd distinctions. If you agree with someone that they will not compete in certain markets, or they'll not produce more than a certain number of goods in a particular area, that's anti-competitive, you accept. But if you simply buy them up completely, it's not anti-competitive. That's the principle.
well, my lord, perhaps because I'm not addressing, I'm sorry, whether something has an anti-competitive effect, so much as whether Section 17 and this legislation as it stands is intended to address this sort of transaction.
Yes. And you say there's nothing in Section 17 itself which restricts its wording. You rely on the structure of the Act. Perhaps we should let you develop the submission about the structure.
Look at Section 17 2B. Agreements covered include agreements to limit or control production, markets, technical development, or investment.
Yes.
Now, on the face of it, if you made an agreement with somebody, a competitor, that he was to limit his production to zero, there would not thereafter be any collusion between the two. Yet it's clearly included.
Yes, well, my lord, my point is not so much continuing collusion between the two. Because I accept the observation that was made, I'm sorry, earlier during argument, that one doesn't need to have an ongoing, you can make an agreement on one occasion which has an ongoing effect. But, my Lord, if I may start with the start of the Act. If I may start at Section 5 of the FCA, at page 958.
But they weren't they doing here, controlling markets, in fact? Digicel were giving up an overseas market and acquiring an expanded market in Jamaica. And is that the right way around? Yes, it is. Yes. And Oceanic were acquiring the overseas market. So there was a sharing of markets. Are you suggesting it makes any difference if that's done internationally rather than internally? I mean, supposing they've done it internally and they say, you focus on gaskets and we'll focus on spark plugs or something, and they've each taken over each other's business in...
just a regional carve-up.
Yes, a regional carve-up.
You'll be the only supplier of telecommunications facilities in Kingston, and the other company will take everywhere else. I mean,
well, to answer that question, my Lord, if you look to page 957.
Sorry?
957.
957, yep.
This is part of Section 2 of the Act. 957 were subsections 3 and 5. Subsection 3 says references to market means a market in Jamaica.
Yes.
And 5 says the effect of competition over market, references to factors that affect competition in that market. And I appreciate, my Lord, that this is not a complete answer to your Lordship's question, but the Act does seem to be focused on Jamaican markets.
You don't look outside Jamaica.
Pardon, my Lord?
Sorry, I missed
The Act does focus on markets in Jamaica.
Yes.
Well, the same point can be applied, can't they? I mean, effectively, this was an attempt to control the Jamaican market by giving, or certainly substantially to affect the Jamaican market by giving Claro to Digicel.
My Lord, if we look, for example, starting with Section 5 of the Act at page 958, it speaks to the functions of the Commission.
The
5.1
Function of the Commission.
5.1a.
51A.
Yes. So it starts with the carrying out of investigations, and this is in relation to conduct of business in Jamaica, as will enable it to determine whether any enterprise is engaging in business practices in contravention of this Act and the extent of such practices. I start there because the functions, the investigative powers, the powers of search, the powers to require documents, they all relate to ongoing business practices. And these are terms which I would submit, my Lord, do not appear to cover a situation such as a total acquisition. If you go to 990, paragraph 7.3,
sorry, which section?
7.3, my Lord.
73. What page?
Paragraph 7, clause 7.3 on page
960.
960.
960.
Yes.
The power to require information is for the purpose of determining whether the conduct of the business constitutes an uncompetitive practice.
But the conduct of business here must be taken to include engaging in agreements contrary to Section 17. Otherwise, the Commission wouldn't have any relevant function in relation to a significant part of the Act, and that can't be right.
Except, my Lord, I would submit that in interpreting Section 17, one should take into account the powers that are given to the Commission. Because the powers that are given to the Commission are presumably given to address the breaches that may arise. And if the powers are limited to ongoing conduct, to market practice.
But a single agreement can be business conduct, can't it, in relation to goods or services, and it can constitute an uncompetitive practice. There's no inference that the Commission can only investigate things which a concern is doing repeatedly or on a continuing basis.
Yes, except, my lord, I would say doing what? So that there are a number of other provisions, and they make the same point, and the same answer could be given. 10.1, I'll just give one more example.
10.1, yes.
10.1.
No, it's absolutely right. Give us the references you want. I don't want to stop you.
10.1, 10.3, ascertaining whether any person is engaging in conduct, and so on.
Yeah.
I cite all these, my lord, and I'll move on now, to make the point that the powers given under the statute and the functions stated are stated in terms which suggest ongoing market practice,
Right.
as opposed to something like a merger and acquisition. My lord, if I may move to the...
Conduct has got to be a continuing scheme of operation or state of affairs. As it's a one-off event, as this your submission can't be conduct for the purpose of these provisions that you're showing us. Is that right?
That's correct, madam. It may be a
The
one-off.
second line of subsection 10.1 includes conduct which a person has engaged in.
Yes.
Yes.
Has engaged in or is engaging in, or likely to constitute the contribution. All those are separate bases for an investigation.
Yes, madam. And to answer the one-off question, there may be a one-off agreement. So there's one agreement that involves ongoing conduct. But, my lord, may I support this point by pursuing my lord Sumption's point and turning to the learning on Article 101? Because both
Are
parties...
those all the provisions that you are wanting to recite on the structure of the Act, or are there other provisions that you wish to found on?
My lord, those are all in this Act. Because I'm going to go to the TCA as well.
Okay.
Those are all in this Act.
So the case.
My lord, both parties in the court below agreed that while there were some differences, Article 101 was sufficiently similar to Section 27 that the cases from the European Court of Justice and the learned text there would be of assistance and guidance. My lord, every one of those cases that are cited and are before the court here, in my submission, support the position I'm advancing. If I could take your lordship to the authorities bundle and start with terminal. The British American tobacco case, which is at tab 8, at paragraph 1090. So the case starts at MS 1087, but and I take a lot to MS 1090. And at the time, the article was 85. In the 5th paragraph on that page, the judgment reads, in order for the Commission to hold that an infringement of Article 85 had been committed, it had to be able to show that an agreement had the object...
Where are you reading from? 109?
1090.
1090, the 5th paragraph, beginning nevertheless.
I see, right, sorry, yes.
For the Commission to hold that an infringement of Article 85 had been committed, it had to be able to show that an agreement had the object or the effect of influencing the competitive behavior of the companies on the relevant market.
Yes.
If your lordships go to the ANIC case at tab 10.
So what do we get out of that for the purposes of this case?
That, my lord, you need to show an effect on ongoing conduct.
Why?
influencing the competitive behavior, which
This is
This is in the
historic effects.
this is in a context where there was both companies continued to exist, and
Well,
it was
no.
just a shareholding
Indeed, my
that
lord.
was being taken, 50% holding.
and indeed, my lords, if you go back to 1089,
Yes.
the paragraph under the Commission's assessment, which has previously been quoted. In that paragraph, the court notes in the second sentence, since the acquisition of shares in Rothmans was a subject matter of agreements entered into by companies which had remained independent after the entry into force of those agreements, the issue had first to be examined from the point of view of Article 85. The point, as I understand it, being that had they not continued, Article 85 would not be relevant. So Article 85 was relevant because they had continued, and therefore, given the finding on the following page in relation to the need to prove ongoing competitive behavior.
You're submitting that if you acquire 50% of a competitor, that is within the jurisdiction of the Commission, but if you acquire 100%, it's not. Seems counterintuitive.
Except, my lord, that it is counterintuitive to the extent that one would have thought that there would be a regime dealing with both issues. But I'd say that the fact is that there's not.
Yes, but
And if I may add, my lord, the fact of the acquisition of the 50% would not in itself result in a breach of the provision or an anti-competitive situation. And indeed, in this case, there were questions of, does that mean information will be shared? Does that mean there will be directorship and so on? So that you could have the percentage interest and not breach the provision.
Does it mean more than that? Because in that case, the two companies remained independent. Article 85 was necessarily something that had to be examined first. Or before you got to abuse of dominant position, which could only arise if there was complete takeover. In other words, it's not saying, or is it saying, that if there was a complete takeover, it couldn't be examined in terms of Article 5?
Well, complete takeover doesn't necessarily mean abuse of a dominant position.
No, quite.
It may bring a dominant position into existence, but the question whether it's abused is a different matter.
Right. Anyway, is there that's the case on this point. Is there any textbook analysis of the point that you're making, which is that Article 85 doesn't apply unless companies remain independent?
Well, if we look at the text EU competition law, which is at tab 23, there's an analysis starting at the bottom of 1389, MS 1389, under the heading Concerted Practice.
Sorry, I'm not. You said 23, did you?
Yes, my lord.
1380, MS 1389.
1389.
I've got it. Yes.
Where the learned author say that 101 is aimed at explicit collusion and so on, coordinate behavior, affect competition. And
Yes.
they then quote from Diastos, coordination, and so on. And it continues. In Suke, it confirmed that the concept in no way required the working out of an actual plan.
Well, sorry, I see. That's right-hand page, 1390.
From
Yes.
operators,
Right.
the object or effect whereof is either to influence the conduct on the market of an actual or potential competitor. And that is where she certainly envisages, they certainly envisage that ongoing competition being by the two persons still in the market, or to disclose to a competitor in the course of conduct which they by themselves have decided to adopt.
Well, that's...
She ends, although therefore the concept does not require an actual plan, it does seem to require reciprocal cooperation or contact through director and their contact designed to influence the conduct of the actor or potential competitor.
That's all in the context of concerted practices, falling short of an agreement. Can one have a merger without an agreement?
No, madam. I would have thought not.
Sorry?
I would have thought not, madam.
No. I mean, you could have a concerted practice under which there's an understanding that a particular line of business will be discontinued by one competitor. That would, I think, be a concerted practice. But it wouldn't involve, it would involve, I suppose, continuing conduct in the market of a negative kind.
We don't have
I know.
page 1391.
Madam.
Next time.
Well, if it matters to your lordships, we will obtain it and put it before the court. It is not presently in the record. My lord, may I then make a final point before going to the to the Telecommunications Act? And my answer to my Lord Hodge was incorrect. There is another, two other provisions in the Fair Competition Act that I should point to. That, my Lord, is not only does the Fair Competition Act not, we say expressly or impliedly address mergers and acquisitions, but in the only two instances where the Fair Competition Act addresses dealings between interconnected companies, it expressly disapplies the prohibitions against anti-competitive conduct. If I could ask your lordships to look at MS 977. Now, this, my lord, is section 33 of the Act, which deals with exclusive dealing. Now, you'll see that 33(2) provides that the Commission can prohibit tied selling. But 33(4), the last three lines, indicates that the section shall not apply in respect to exclusive dealing or market restriction between or among interconnected companies. I'm sorry, I should have indicated that 3C allow the Commission to take steps in relation to exclusive dealing or market restriction. And they then go on to expressly disapply that to interconnected companies.
What, in 4?
In 4, yes, madam. They do the same thing in paragraph 34.
This section shall not apply in respect to exclusive dealing or market restriction between or among interconnected companies. But that postulates that they're already interconnected, doesn't it?
I mean, that
Yes, it does. It does not.
reflects the basic principle of virtually all competition law systems, that they're concerned with economic and not legal entities.
You look at groups.
Yes, and my lord, this is no doubt.
Yeah.
There's a similar provision in the following provision in relation to price fixing, so that 34(1) forbids certain actions, and 34(2) says it doesn't apply where the person attempting to influence the conduct of another is an interconnected person.
Because in that situation, there is only one economic entity.
And my lord, in fact, what no doubt supports your lordship's observation is that on page 957 in the definition section. The very first paragraph at the top of the page, 2B, says a group of interconnected companies shall be treated as a single enterprise. So that, supporting what my Lord Sumption has said. I cite these, my Lord, to say that all these provisions support an interpretation, in my view, that the Act is seeking to deal with.
I wonder about that. I mean, these two exceptions in which you found in sections 32, 3 and 34, they don't apply where there is a single enterprise. It doesn't follow from that the creation of a single enterprise which has an anti-competitive effect is out with the scope of section 17.
Yes, no, I accept my Lord.
It assumes, as my Lord Mann said, that they're already interconnected.
Yes.
But there hasn't been a merger to engage the functions of the Commission. But there has here.
My Lord, I would not, and I'm not suggesting that these two exceptions taken by themselves could have that effect. I'm saying the scheme of the Act, that all the provisions point in the same direction. Well, my Lord, let me go on to the Telecommunications Act. Because the Telecommunications Act created a regime, and your Lordships in the questions asked earlier.
But you are leaving a great lacuna, aren't you? You look at groups as a single enterprise. Where you have separate enterprises, they can't engage in anti-competitive arrangements if they remain independent. So they can't actually carve up markets, agree that one of them will concentrate on this market and another will concentrate on that market, and so on. But they can achieve precisely the same arrangement by taking over the bit of the other which deals with the market which the other doesn't want to concentrate on, and you do. And there's no statutory regulation of that sort of agreement at all.
There is, my Lord, in the Telecommunications Act and the OUR Act.
Well, no, but leave aside telecommunications. Let's talk about widgets.
Well,
or something else which is nothing to do with telecommunications.
there may well be a lacuna in the legislation, my Lord.
Sorry?
There may well be a lacuna in the legislation in regard to widgets.
So, and indeed, there was a lacuna in relation to telecommunications until the Telecommunications Act, you say.
Yes, my Lord, in this,
Yeah. So,
keeping in mind, my Lord, that prior to the Telecommunications Act, there's only one provider.
yes.
So that the need for competition issues there was more limited.
Right. All right. Now, carry on then.
And your Lordship had made the observation earlier that there was limited material before the court as to the background of the Telecommunications Act.
Right.
But what certainly is, I think, before the court and accepted, is that prior to this act, there was only one provider. And this act was brought into force, was enacted in order to deal with the new situation of multiple providers. And, my Lord, here's what it did. And there's a question that has been asked, which is, to what extent did this act, the Telecommunications Act, and the OUR deal with competition issues?
Well,
Let
even
me
before
address that.
2000, it would presumably Cable and Wireless was the one provider before 2000, was it?
Yes, madam.
So, even before the Act, would the Competition Authority have been empowered to take measures against Cable and Wireless on the ground that they'd abused a dominant position?
Yes, madam. And indeed, there are other things in the Fair Competition Act, such as misleading advertising, say, that might have applied. So there are various other things in the Act which would have applied. And I'll indicate,
You submit that the position after 2000 is that abuse of dominant position was removed from the remit of the Competition Authority in the case of telecommunications, or is it just agreements?
Well, our position is that the Telecommunications Act creates a regime that solely governs telecommunications matters in the areas where it addresses. there are areas, if I may just complete the answer to your Lordship's question, in the areas that are not covered by the Telecommunications Act, the FTC and the Fair Competition Act continue to apply, such as abuse of dominance.
So, what's the position about abuse and dominant position after the Telecommunications Act? Is it no longer within the remit of the FCA, because there's an exclusive scheme under the Telecommunications Act? Is that the result?
It is not, my Lord, because that issue is not, as I recall, covered by the Telecommunications Act. So that it is only exclusive to the extent that it deals with an issue.
So abuse of dominant position is governed by the Fair Competition Act.
I mean,
My Lord,
since 2000, has abuse of a dominant position been covered by the Telecommunications Act, by the Fair Competition Act, or by both?
my Lord, if I could take it to page 12024.
Page?
1024.
Thank you.
I was going to go here for another purpose, but it's been observed, my Lord, that there are many references to the Fair Competition Act and the Fair Trading Commission in this legislation. This is one of them. This section, section 28, gives the OUR the power to determine whether public voice carriers should be declared dominant or not. And the only relevance, the only need, reference to the Fair Trading Commission is that the OUR must consult with it. Now, what this act then does is specifically give the OUR the authority to determine whether an entity is dominant or not. It does not go further to deal with the consequences of an abuse of dominance.
It's not dealing with an abuse of dominance. It is imposing on the dominant public voice carrier obligations of interconnection. Is that right?
I think that's correct, my Lord. Yes.
Which is exactly the same as EU law achieves under the telecommunications and the interconnection directives. There are different provisions relating to economically dominant and other enterprises. Basically, the difference being that you can impose an arrangement on an economically dominant one, whereas non-dominant ones are at liberty to reach agreements which, on the face of it, will be respected for the purposes of the law. That's a fairly common arrangement. It's nothing to do with abuse.
No, so that my original answer to your Lordship as to whether the Fair Competition Act, which has a provision, has three provisions dealing with abuse of dominance, whether those continue to apply. They do, subject to this, who determines whether there's a dominance. But this act, the Telecommunications Act, doesn't say what happens in the event of an abuse. So that...
No, it doesn't, and that's right. Abuse would still, therefore, be governed by the Fair Competition Act.
Exactly. But, my Lord, if I can go back now to look at what is the scope of this act vis-à-vis competition.
Yes.
So I think it's a critical issue in the case. Now, in 2000, against the background that we've discussed, starting at page 1003, and I'll start at section 4, where the Telecommunications Act provided that the OUR, the office, shall regulate telecommunications in accordance with this act. And it's been observed that 41F says its functions include promoting competition. And 3A says the very first object of the act is to promote and protect the interests of the public by promoting fair and open competition.
This is the Office of Utilities Regulations, is it?
Yes, ma'am. It's called the office, the OUR. But, my Lord, two things have not been pointed out to you or commented on before. At the same time that was done, the OUR Act was amended. If your lordships go to page 946,
(946).
yes, my lord. The first schedule which set out the prescribed utility services under that act was amended in 2000 to add the provision of telecommunication services.
Sorry, I'm not with you at the moment.
At the top of 946, my lord.
Yes, right.
First schedule, prescribed utility services. You'll see it from the note at the top right hand of the page. Act 14
As amended, yes, I see that.
Yes. So item 1, the provision of telecommunication services, was added in 2000.
Yeah.
Now, if your lordships then go in that same act, the OUR Act,
This is at the time that it was envisaged that cable and wireless might not continue to enjoy the monopoly it had previously enjoyed.
well, it was known, my lord. Yes, because the telecommunications are provided for the grant of new licenses. Now, if your lordships then go to section 4, which starts at 935.
935.
Yes, my lord. So that 935, section 4, sets out the functions of the OUR. And section 3, which I think answers a question that my lord had asked, says, in performance of its functions, the OUR shall undertake such measures as it considers necessary or desirable to A, encourage competition in the provision of prescribed utility services.
This is all as from 2000, is it?
Pardon me, Lord?
This is as from 2000.
Well, it had this power from 1995, but as from 2000, telecommunication services was added to the definition of prescribed utility services. So that this act was passed in 1995 with this power, but the prescribed services at that time.
Section 4 is a 1995 provision.
Yes, my lord. But in 1995 it did not apply to telecommunication services.
No, because Section 4 was amended by Act 14 of 2000 in Section 4.
But certainly as of 2000, Section 4, subsection 3A, and the first schedule, item 1, were in place.
So there's a power to encourage competition.
Well, I would say a little more than that, my lord.
An obligation to use their other powers in such a way.
To undertake such measures as it considers necessary
Right.
to achieve that.
Right.
So we then had a situation, my lords, where the Telecommunications Act is put in place, provides in various places for the OUR to deal with competition issues. And it's been observed, my lord, that in many places the Act refers to the Fair Competition Act and the Fair Trading Commission. But it consistently does so in ways that cut down the authority of the Fair Trading Commission and vest the authority in the OUR.
Where is that?
For example, my lord, sections 25, 28, and 35, I think, are all to that effect. So section 5,
Let's have a look.
which speaks to the OUR referring certain matters to the FTC.
Or is Section 5,
Section 5 on page 1006. I'm sorry, I'm back in the Telecommunications Act. I apologize. In the Telecommunications Act at page 1006. So Section 5 provides, where after consultation with the FTC, the office determines, so it is the OUR to determine that there's a matter that meets these two criteria, it must refer to the Commission.
Yes.
That's not, that is, the reference then vests the authority of determining competitive significance on the FTC, not the OUR.
Yeah.
I merely,
Hang on, the office determines, after consultation, that something has substantial competitive significance, which basically, that's not determining whether it's anti-competitive, but simply determining whether it has implications.
Yes.
And if it does, it's required to refer the matter to the Fair Trading Commission.
If it falls within the FTC's functions.
right.
Yeah.
But
That rather tends, surely, to suggest, contrary to your submission, that the FTC does have jurisdiction.
it has jurisdiction, my lord, to the extent that the OUR has made its determination.
Well, is this an exclusive procedure? Is there anything which says that the FTC cannot also act on its own initiative? This simply provides, I mean, there are a number of people who can refer things to the FTC, the minister in certain circumstances, the Office of Utilities Regulation in this instance. But is there anything that says the FTC may not act otherwise than on a reference?
No, my lord, nothing that says so specifically.
And the FCC, on any view, has a completely open power, all its ordinary powers, doesn't it, unrestricted, if a third person refers a matter to the FCC. Is that right?
Because of
Under Section 73, subsection 2.
Yes. Well,
But
so the Act specifically doesn't take away that power and that right.
But how does this work? I mean, here a third person did refer the matter to the FTC, but you say that's not good enough because you also have to establish, what, a causative link between the FTC deciding to investigate and the report from the third person. Is that the case?
My lord, that is the case, but I would describe that as a minor point.
As a what?
As a minor point.
Well, no, but it's quite an important point because it leads to one to ask, what's the sense of this? Why should the FTC's very full powers and very important powers in public interest depend for their application upon, firstly, whether it's bright enough to act before some third person reports the matter, and secondly, if a third person does report the matter, upon an inquiry into, by inference, not expressly in the language, causation as to what has really caused the FTC to act.
Well, the FCC can act on its own initiative.
Yes, I know, but I think the argument is it can't because it can only act under one of the sections of the Act. And I was just testing that. Would that be a very sensible scheme if one is trying to look at the coherence of the Act?
My lord, I accept that. It would be odd to have a limitation to persons making complaints.
Yes.
But that is what the Act sought to do. So, because what the Act did, my lord, is created a regime, and as I had said before, left some things for the FTC. And it chose to leave situations where members of the public made complaints.
So, I mean, what does this mean? This is the FTC, if it sees something which is flagrantly anti-competitive in relation to telecommunications, has to bite its fingers and say, let's hope somebody complains. And if they do, we can then act. But if we act of our own initiative, we won't have power.
No, my lord. As I had indicated previously, and the reason why I say it is a minor point is that, as I had indicated previously, I accept that a matter not covered, for example, and I gave the example of misleading advertising, but let us say an agreement to fix prices. An agreement between telecommunications providers to fix prices is not a telecommunications transaction envisaged under this Act. It's not addressed by this Act. And I would accept is a matter that would breach Section 17 of the FCA, or which the FTC would have jurisdiction. And that one would not need to look to a complaint by a competitor, by a consumer. So to give a direct answer to your Lordship's question.
How do we know if it's a telecommunications matter or not?
If it is covered by one of these provisions.
When you say when it's covered by one of the provisions,
Well,
the provision you're referring to here, the license provision?
Well, let's deal, my Lord, specifically with Section 17 and the transaction in this case.
Yes, I see.
If I may go there.
So if some section of this Act touches on or affects the transaction, then the FCA falls out of consideration.
I wouldn't be so bold as to say touches on our concern, my Lord. I would say addresses.
Addresses. But the trouble is this doesn't address, if we look at Section 17, it's a precondition to assignment of a license,
Well,
but it's dependent upon satisfaction of requirements which have nothing to do with competition law.
Okay, and that is where, my Lord, I would respectfully argue to the contrary.
Okay, so what's the argument?
And I accept, my Lord, that this is a critical part of this case. Does Section 17(2) provide for a consequence that is different from that in the Section 17 of the other Act? Are they dealing with different things? Section 17(2), my Lord, on page 1018, does not say that a licensee may not transfer its business without approval. Had it said that, one could construe that as saying the Act is merely creating an additional precondition. What the section says is a licensee may assign it with the approval.
It must mean that a licensee may not, without prior approval. I mean,
Yes,
what are the terms of these licenses? I suspect they probably say something about this.
I agree that it does mean that as well.
It does.
But by phrasing it this way, it permits the licensee to transfer once he has the approval.
Yeah.
It says you may do so if you get this approval.
Yes.
And because this is where the observation I made at the start about the nature of this agreement is so important. The only thing that is being complained about as being anti-competitive and breaching Section 17 of the Fair Competition Act is the transfer of the business, is the acquisition of the business, which is exactly the thing that this section says may be done with the approval of the minister. And that, my Lord, is the reason why I submit. The two sections deal with the same thing.
But do you accept that 17.3 restricts the grounds on which the minister can withhold his approval?
It does, my Lord.
Yes. And those grounds do not include grounds of competition.
Except, my Lord, that because the Act requires the OUR to advise, requires the OUR to take such action as it thinks fit to protect competition on the other legislation. The legislation does see.
Forget about the OUR because we're talking about the minister here, and there's nothing which involves the OUR here, is there? This is there's nothing which says that the OUR has to be involved. I suppose it could get involved.
Well, because, my Lord, the minister, there was a discussion earlier, and as your lordships have observed, there is a restriction in relation to 11(1)(b).
Yes.
A restriction in relation to the applicant, and I appreciate that it is the applicant being disqualified. And that disqualification is, I think, would need to be read along with the OUR's powers to approve a person as fit and proper for the purposes of getting a license. So the OUR must say, it would seem to me from the scheme of the Act, that this is an appropriate person to be a licensor or a licensee.
I mean,
If
suppose...
your lordships look at,
Yes,
at
yes,
1019 at 11.2,
yes.
1012, page 1012 at section 11.2, in deciding whether to recommend to the minister that an applicant be granted a license, the OUR shall do various things, including C, have regard to such other matters as the office considers relevant. And when one reads that, along with the purpose of this act, the very first item being protect competition, the functions of the OUR under the other act, which specifically speaks to that, I would submit my doubt that this scheme allows for the OUR in making, not only allows, would require the OUR in making that recommendation to consider this very issue.
Which bit of section 11, let's assume that you're right, that section 17.3 means that the minister would take the advice of the office, which I think is your case, is it?
Yes, ma'am.
Which of these subsections of section 11 show that the office would then be considering competition matters in this context?
Well, my lord, since
Which one?
it's not in this act, my lord, it's in the
Nothing.
OUR Act, which says that the OUR, in exercising its functions,
But the difficulty is that the minister is bound to grant approval if he's satisfied that the assignee satisfies the requirements of Section 11. And Section 11 is focused, as you accept, purely on non-competition requirements of the assignee.
so I don't know, my lord, that one can divorce that from A, the OUR's, the need for the OUR to be involved in that process by reason of 11.2, and B, the OUR, both this act and the other acts, specific reference to competition issues
Well,
and the need to...
my difficulty with your...
Other than competition regulation,
Sorry, ma'am.
the OUR has many functions other than dealing with competition issues,
Yes, ma'am.
which is no doubt why their advice is called for.
At the end of the day, 17.3 confines the grounds on which the minister can refuse his approval to his being dissatisfied that, as to the compliance with 11.1a and b. 11.1a relates to the
That's not relevant.
assignee giving undertakings in relation to certain obligations. 11.1b relates to the assignee not being disqualified from holding a license. In this case, the assignee already has a license.
Yes, my lord.
So, how does competition come into this at all?
My lord, would it be, if the OUR can take such measures as it thinks fit to advance competition, and the assignee acquiring additional license within the OUR's view constitute substantial listing in competition, would have consequences which were inappropriate and in breach of the purposes and effect of the Act, then it would seem to me, Lord, that it would be appropriate for the OUR to determine, to advise against that, given this pause in Section 2, and if the OUR concluded that the person was not a fit and proper person to hold both licenses, that would then be an impediment. But my lord, I don't know that I need to go that far, because even if it be the case that Section 17 of the Telecommunications Act allowed a transfer and an acquisition without fully taking into account
Yes.
competition issues. We do have a situation where it allows the acquisition of the business without reference
To competition
to
matters.
the FTC.
Yes. But how far does that go? I mean, supposing that you say that Section 17 can be read as a permission, whatever the competitive position, can it override all rights? Does it give you an absolute right? Supposing the licensee has bound itself by contract with some other third party not to assign its license, would the minister's prior approval override that contract?
No.
You say it can override competition law.
No. What it overrides is a previous, if there is a situation, because you also have to recall, based on our earlier argument, there's no conflict because the Section 17 of the Fair Competition Act doesn't apply to this transaction. But if it,
the mergers and acquisitions, yes.
yes. But if it does, you then have a conflict.
Yes.
Is there a conflict? If you have a number of different statutes, each of which imposes legal conditions on the right to engage in a transaction, why don't they all apply cumulatively?
Because, my lord, that could be the case if one could interpret them as saying, you must do this and you must also do this. But if the latter one says, you may transfer if you do this, I would submit that that can only be construed.
It's permissive. It's making clear that licenses, which normally would be, I imagine, well, certainly they'd be personal because they depend on fitness and propriety and that sort of thing. It's saying these are assignable, but you have to get prior approval to check out that you too are a suitable person. The assignee too is a suitable person. So why do we need to read it as anything more than permissive in the sense of overriding the usual presumption that it wouldn't be assignable? Why do we treat it as permissive in the sense that it excludes ordinary competition law or any other binding commitment?
Because, my lord, and setting aside any other binding commitment,
Yes.
in relation to competition law,
I see.
this act that was enacted in 2000 to deal with a specific sector in a new regime with wider competition, appointed a new regulator, said that the regulator would deal with competition issues, said that the minister, that you may...
That gets us back into the argument we had a few moments ago as to whether, when you trace whether that's really consistent with a requirement on the minister to grant approval if satisfied of rather limited things which don't relate on their face to competition. You say, oh, well, there is a general responsibility of the OUR which it could feed in.
Yes. And
Section 17 of the Telecommunications Act would apply, among other things, to the simple assignment, bare assignment of a license in a context which involved no merger at all. It's not actually concerned with mergers, although mergers are one occasion which may give rise to an application to assign the license. It's only concerned with the assignment of a license conferred by the state to carry on a particular sort of business, and it's protecting the integrity of the licensing system.
Well, no, it also goes on to talk about transfer of control of operations in 17.2.
Yes, but there are alternatives.
Yes.
17.2
Yes. They are
allows, with the prior approval of a minister, the assignment of a license or the transfer of control of its operations.
And
Which was it here, actually? It was both, was it? It was assigning a license and rights thereunder and transferring control of its operations. It's all three.
yes, no.
Yeah.
And it's important that it is all three, because if it were mere the license, then one could say, and indeed, my lords, I'll bring your lordship's attention to subsection 13.3, which on page 1014, which to some extent supports my Lord Sumption's point. Subsection 3 says, a license granted under this section, and then in B, the license shall not be assigned or otherwise transferred, except in accordance with this part. So that,
Yes.
I appreciate that that supports my Lord Sumption's observation, but this doesn't deal with the entire operation. control of the business.
Yeah,
So that-
presumably the license is granted in connection with a specified business.
Yes, it would be. But you can transfer one and not transfer the other.
Right. So where are we now?
My Lord, there is an important point that arose earlier in relation to the power in Section 35 to make competitive safeguard rules. And as your lordships know, Section 35 provides that the OUR may make rules, competitive safeguard rules to cover various things. The question was asked as to the status of those rules. I do not know, my Lord, the answer as I stand here, but I certainly, if we will sit until after the break, I will certainly ascertain the answer by then. There are two other matters I would address, however, in the meantime, but I flag that to say that is an issue that, although your lordships have not asked me the question, I don't know the answer, and I would like to have an opportunity to.
Yes. There were draft rules, I think, about 10 years ago in 2007, which were consulted on, but they didn't deal with mergers. They dealt with questions of interconnection and such things. I don't know if they were ever issued in final form, but I'd be very interested to know.
Yes.
I don't
Well, you
know.
could perhaps take time and give us that in writing within the next week, say, after this hearing, just to make sure you get it right.
Yes.
Trying to find something out over the adjournment may not be the most fruitful course.
Yes.
So what points do we
My Lord,
go to or need to go to next?
if I can comment on two other issues, my Lord. The question of business inconvenience, and I appreciate that your lordships have observed that an answer to that may be that they deal with two separate things, with two sections. But I'd observed that, my learned friend's submissions, that there's the finding of business inconvenience is speculative, in that one does not know whether the transaction would eventually be approved by the FTC, given the provisions.
That's true of any agreement or concerted practice.
Except, my Lord, that I'd point out that the FTC has already taken a position on it and what the ruling would be. So that in bundle 1, starting at page 18, your Lordship will find the report that the Fair Trading Commission did in December. And your Lordships will recall the chronology here, which is that the approval was granted in August. There was a challenge to the approval in court proceedings in September. That challenge failed. The transaction was completed in November. This report was issued in December, and the litigation started thereafter. If your Lordships turn to page 64, at paragraph 170.
All right.
Your Lordship will see that the FTC there took a position, and in the last sentence made a recommendation about the transaction being blocked. I started to say, my Lord, that if I am right on the interpretation of the sections, the business inconvenience is plain. One need not speculate as to what would happen.
Just tell me, at this stage, the transaction hadn't been completed, is that right?
It had been, my Lord.
It had been?
It had been.
So it's a rather odd report saying is likely.
So
Well, perhaps
it came too late.
Came too late.
And my Lord, this is a situation where, on the FTC's case, they were aware in March of the transaction. There are public statements in the months following that the minister is consulting with the FTC and the OUR. The minister grants the approval in August, and this happens in December.
Well, the parties may, on the FTC's case, have implemented an unenforceable agreement, and quite what the effect of that is in law, indeed an illegal agreement, I think. Well, just unenforceable at any rate. So we can't speculate as to what the effect of that is, but we got the report. What do you get from the report, then? You just say it's pretty inconvenient if it comes after the event. I suppose the lesson for the FTC, if it's right otherwise, would be it ought to actually take some interim steps to stop.
I know that I said this to respond to the submission that the business inconvenience filing is speculative. That's what I said.
You say there is an actual inconvenience.
Yes. And
If the FTC wished to block something that the Minister has already approved.
And that's been acted on, yes, ma'am.
Yeah. The actual inconvenience is that they didn't act, and we can hardly construe the act because the FTC failed to take the normal steps.
And it should smell out.
All of this discussion assumes that there's in fact no power to direct divestment.
Right.
Yes. And the reason my Lord why it's relevant is this. If the section 17 of the Telecommunications Act, which says a licensee may transfer its business or may acquire another entity's business with the approval of the minister, is permissive in the sense that it allows. And if the Act has what is a complete scheme, although imperfect,
Yes.
then you have a situation where an investor could properly act on that, or could think he properly acted on that, and then be told later that, as has happened here. So the interpretation, I know, doesn't turn on what was actually done, but what was actually done here is an example.
Trouble is, it's a circular argument. I mean, we have to decide whether a life can really be run quite like that.
In a way, my Lord, I'm responding to a circular argument with another one. My Lord, finally.
I won't put it quite as I was thinking of putting it, but it might be a bit easy if you're thinking of entering into an anti-competitive agreement, if it did work like that. And I appreciate your client has not suggested they were thinking of entering it in the sense of intentionally doing so.
My clients thought that they were entering into an agreement that needed the approval of the minister.
They thought they had
My Lord, I'd finally observe that the record, as your Lordship should have noted, does not include the ministerial approval, which everybody asserts and agrees was granted.
Yes.
And does not include any correspondence between the respondent and the appellant.
Do we have copies of the ministerial approval?
We do, my Lord.
It'd be helpful to have them.
Yes.
Are there any other documents which either of you thinks?
My Lord, there are three documents that, again, that I've shared with my learning friend before, that I would hand in.
That's very helpful, yes.
There are two ministerial approvals,
yes,
because it was approved with condition. My Lord, there is something I do need to address. There was reference, my Lord, to page 205 of the record, the ministerial Prime Minister's statement in Parliament. And there's something that I do need to point out.
Yes.
Your Lordships noted that at page 206,
Right.
there's a reference to the Attorney General's opinion.
Page what?
206.
Volume 1 of the record, page 206.
Thank you very much.
So at page 206, there's a reference to the Attorney General's advice.
Yes.
And at page 207, in the paragraph beginning, given
Yes.
the circumstances and the statutory constraints placed on the minister in exercise with discretion, I have approved the acquisition of Clara and so on, without any modification. That statement, my Lord, has nothing to do with competition, because the advice on page 205 is as to whether he can impose conditions.
Yes.
And he's saying
Well, presumably, what were the conditions about?
well, my Lord, you'll in fact...
It was rates, wasn't it? It was retail charges and so on?
My Lord, if your Lordship looks at the letter I just had dated August 23, you will see that there were conditions or a requirement and if you Lordship look at the November approval, the subsequent minister confirmed the approval, removing the requirement of maintaining separate networks and accepting some commitments that had been given.
There'd been an election, had there, or a change of Prime Minister?
It was a change of Prime Minister, not an election. Same Prime Minister, same party.
Without an election.
Correct.
Right.
And my Lord, the other document that your Lordships have just been handed, did you receive a letter dated April 19?
Yes?
My Lord, that is relevant only because it is the last correspondence between the parties. There was some correspondence in March. And the last correspondence was this communication from Digicel to the FTC in April. And so when your Lordships look at the chronology of events, you can add this to it. Because effectively the next communication was the initiation of these proceedings in December.
Well, Digicel is declining to cooperate with FTC because it asserts that FTC doesn't have jurisdiction.
It took the same position it's taking in this litigation. So if your Lordships look at the chronology set out at pages 915 to 916 of which are our case, 915 to 916.
Sorry, 915 to 906. Your case.
This one.
What paragraph in your case?
15, my Lord.
Thank you.
So that what you will see is that after the
Well, there was a public announcement by the Fair Trade Commission that it had completed its assessment in July, so your clients presumably knew about that.
and the minister then approved it the following month.
Yes.
All this.
These are facts particular to this particular case, but they can hardly construe the statute, can they?
My Lord, this was included in response to a submission as to what Digicel knew or did not know.
Yeah.
And I raised that, no, both in the context of the discussion earlier as to what steps the FTC could take now, and also because of these developments and these actions by the respondents were consistent with the interpretation of the legislation that I have advanced, which is that there's a effectively self-contained regime which provided for and allowed the completion of a transfer of control of operations upon getting the ministerial approval. So I'm merely saying it's consistent with our interpretation.
You behaved in accordance with your interpretation. Well, perhaps not too surprising. Right. No, that's very helpful.
Lord, unless I can assist you with anything further.
No, thank you very much indeed.
Say for the the matter.
Yes,
that you're
please,
not-
please obviously let the other side have
Of course.
it as well, and when you send it to us, and they'll be able to,
We seek to agree before.
they'll respond if there's anything they want to say. Thank you. Mr. Powell? Thank you very much. Yes, Dr. Beckford.
Please, Madam. I guess I'll deal with the last point first because memory fades, and I think the time as it is. On the question of the inconvenience and the reference to the FTC's finding, I guess I'll start by saying that the approach of the respondents on the question of inconvenience is one of an ostrich. So they started from the proposition that only one body of law would apply to them, and then took the position that if two pieces of legislation would apply, then it would be inconvenient for them. But the chronology which is set out in our statement of case indicates, and we go back to that would be, we're at paragraph 73 of our statement of case, which is 93. 903. That's 903 in the, let's stop 5, 903. Electronic bundle 903, my lord. So at the date of the agreement between the parties, between the respondents, is March 11, which is long before the transfer of the license. Our position is that it was open to the parties to approach the FTC under Section 29 of the FCA, which deals with authorizations. In other words, a party can approach the FTC with a view to seeking authorization of his agreement, so that the result which is suggested as inevitable is not an inevitable result if one, for example, is invoking 29, or an agreement can be considered under Section 17 of the FCA, dealing with agreements likely to impact competition and the like, for a review of the agreement if to determine what sort of, how, if at all, issues relating to competition can be addressed in a targeted manner.
Sorry, which is the section dealing with review?
I'm sorry. I was at Section 17 of the Fair Competition Act.
Yes.
That the agreement can be reviewed under that section, which is 17.4, my lord.
There's no provision for a review, but you say there's nothing to prevent the person planning this agreement approaching the FTC and saying, would this agreement fall foul of Section 17?
Exactly so. Especially in a case whereby if sufficient due diligence had been taken, or if the advice provided had been followed, assuming that proper advice had been given, then it would have been clear to the respondents that when looking at the Telecommunications Act, that act alone could not govern their transaction. And therefore, it would have been open to them to seek to engage the Commission, or even if they chose not to, at the very least to participate in the investigation which had begun. But they chose from the very beginning to say, you have no jurisdiction. Yeah. And then to complain that if the court were to find that the act applies to them, or if any suggestion were to be made that the act would apply to them, that would be inconvenient. But the second point to make in respect of that is that because the agreement has already been executed, whatever the finding of the Fair Trading Commission may be with respect to the likelihood of the agreement being anti-competitive, because the agreement is executed, it cannot be unscrambled. So the only remedy that is available, if a finding were to be made that by the court, because we are not allowed to make findings pursuant to stock exchange. So if a finding were to be made that the agreement is anti-competitive, the only, well, I'm recalling what Lord Sumption said, although with respect to the injunctive remedy, we would say it's a theoretical possibility. But the actual remedy that would be available in our submission is damages in the circumstances.
Damages or a fine?
Or a fine, my lord.
Yes, fine. Well, that happens quite often in competition law.
Yes, my lord.
Right.
And if, so that we say that the inconvenience is not inevitable, and even if one were to suggest that that inconvenience would arise, we would say that it is intended that it should operate like this if you disregard an important body of law. Yes. Otherwise, it would be absurd to suggest that you could disregard a body of law and that the consequence intended should not apply in the circumstances. So again, we would say that that inconvenience, if it were to happen, we would classify that as self-inflicted. That's what we would say. Yeah, we're going to. Yeah.
Right.
And I will now go back to where my friend started, which he started at section 101 of the TFEU, or the EU treaty, on the question of separate and independent undertakings, pre and post agreement. And he relied on 101 to suggest that the jurisprudence therefrom should at the very least be persuasive with regard to interpreting section 17.
What jurisprudence are we referring to? He cited one case.
Yes,
British American Tobacco.
BATS.
Yes, BATS.
But
I mean, have you got any authority on this point? Can you point to case law or any textbook authority which says that BATS doesn't mean what Mr. Hilton submits? It does appear to draw a distinction between Article 85 and Article 86.
Yes, my lord. I think BATS, the BAT case is a case which illustrates, though does not say definitively, but it illustrates that the undertakings in that particular case were separate after. But it's not an authority for the proposition that the undertakings must remain separate post the agreement. In fact, that case was cited for the proposition that 85 or its equivalent, Section 17 of the FCA, can apply to a company acquisition agreement. That was why that case was cited. Not for the restrictive position.
No matter why it was cited, it may have proved less favourable than those citing it would like.
Yes.
I think the submission.
Well, and in answer to that, my lord, we would say that the position of my friend regarding the pre and post, that the organizations must be separate and independent, pre and post, presupposes that the wording of Article 101 is identical to that of Section 17 of the FCA, and it is not. So if we were to go back to the wording of Section 101, which is at tab 5, MS 1059. And it says, my lord, the following shall be prohibited as incompatible with the internal market. All agreements between undertakings, decisions by associations of undertakings and concerted practices which may affect, and so on. Importantly, Article 101 identifies the subjects to be caught by the provision, undertakings. There's no such limitation with respect to Section 17 of the FCA as focusing on particular subjects, or the form of the subjects, for that matter. And there's no such limitation in Section 2 of the FCA, which speaks to the definition of what an agreement is. It says any agreement, whether intended to be legally enforceable. The other point by my friend is that market conduct refers to continuing conduct. And we say that that is in violation of the clear wording of Section 17. But before going to Section 17, let me go to Section 5 of the FCA, because I think that's where my friend started, which is MS 958. When my friend referred to 51A, the functions of the Commission, to carry out on its own initiative or at the request of any person such investigations or inquiries in relation to the conduct of business in Jamaica as will enable it to determine whether any enterprise is engaging in business practices in contravention of this Act and the extent. And he relied on this to say, I guess because it says engaging, that the practice must be continuous. But my friend neglected 51B, though, to carry out such other which addresses his point, to carry out such other investigations or inquiries as may be requested by the minister, or as it may consider necessary or desirable in connection with matters falling within the provisions of this Act, which brings us now to Section 17, which is a matter falling within the provisions of the Act. And in Section 17 says, this section applies to agreements which contain, that have or are likely to have, in other words, it's also addressing past conduct. And so that position is very clear, that the scheme of the FCA is not limited to continuous market conduct, as my friend would have us believe. My friend then went to the OUR Act, suggesting that the OUR has competence to address competition issues. Our submission is that whatever competence it has with respect to taking into account competition issues, that competence is not exclusive, and the whole legislative scheme of the related Telecommunications Act, which recognizes the authority of the OUR, clearly stipulates the jurisdiction of the FCA in telecommunications matters, except where it is expressly excluded in Section 73. Right. And I recall my friend in alluding to Section 5 of the TCA, suggesting that unless the TCA specifically grants jurisdiction to the FTC or expressly refers to the applicability of the FCA,
Yes.
then the FCA does not apply. But both courts, both the Supreme Court and the Court of Appeal, have held, as Lord Sumption recognized quite carefully, that if there is no reference by the OUR to the FTC can act independently. Both courts have recognized that and have said so.
Well, it's a matter for us to decide, really. So it's obviously we give due weight to the views of the court below, but we are here as an appellate court. Now, are there other points that you need to deal with in reply?
If there are no other clarifications, my lord, those are my submissions.
Well, much obliged to counsel on both sides for their helpful written cases and for their succinct oral submissions. And we look forward to the further information which we're going to receive on one point. And having received that, the board will take time to consider what advice it will humbly tender to Her Majesty.